Yes, good evening to the aspirants of the PGLCET 2022 conducted with Osmani University. And today we are going to deal the criminal law and tort. Multiple choice questions. Today and tomorrow that we'll deal the both the thing. So now read what I posted on the screen. Oh, it is gone.
Good evening to the students of PGLCET 2022 Criminal Law MCQs on the Law of Tort and IPC. Professor Dr. Mohammed Saheb Hussain.
Yes. So now let me deal the first part of it. Something later I'm switch out to the host to the Kolikanda Sharad Babu. Okay. Now let us start the PGLCET 2022 University College of Law, Osmani University, Crimes and Tort, and the MCQ. The first question goes in this manner. It is the primary duty of dash to protect its citizen from any harm. Option A, the court. Option B, the IPC. Option C, the tribunal. Option D, the state. Which one is
Option D, sir, the state.
Yes, it is the state, primary duty of the state to protect its citizen from any harm. That is the duty of the state. The second question. An individual is vested with rights by the state to use force to fend off the immediate threat to his or someone else, property or person. This right is the right of dash. A option, private defense. B, self-defense. C, individual defense. D, only A and B correct.
Option B, sir, self-defense.
Wrong.
Then it should be D then, A and B.
It is the D, A and B is the correct answer for the second question, because for the, we can say the private defense and self-defense. Self-defense to the body, private defense to the property. Is it clear?
Yes, sir.
Very good. The third question. Every country should provide its citizen with the right of private defense to protect his dash. Which one is odd man out? Not connected with the question, third Q. It is entirely different. Option A, life. Option B, liberty. Option C, fraternity. Option D, property.
Fraternity, sir. Option C.
Yes, it's the fraternity is not there because it is there in the preamble. Okay, now the life is secured, liberty is secured, property is secured by the self-defense or self-help also. Fourth question. One of the main principles on which the right of private defense is based is the dash of the defense used. Option A, carefulness. Option B, sensibleness. Option C, reasonableness. Option D, soundness.
Option C, sir, reasonableness.
It is the option C is the right answer. That is the reasonableness is the right answer for the question. Next, fifth question.
There should always be reasonableness in self-defense.
Yes, that is a very important factor. Fifth question. Section 100 of the IPC specifies situations in the exercise of the right to private defense of the body extend to causing death. The right of private defense of the body extends to the voluntary causing the death or of any other harm to the assailant if the offense is of a nature herein described. Find out which one is false. Among the four, one is false. A option. Such an assault may reasonably cause the apprehension of death. B. Such an assault may be reasonably cause the apprehension of grievous hurt. C. Option. An assault with the intention of the committing nuisance. D. An assault with the intention of gratifying a natural lust.
Option D, sir.
No.
I think
Because
it is
lust is there. Carnal knowledge, oral sex, sodomy, these are all the things will come. Then the right answer which is not correct is
C.
C is not connected with one. Because actually they committing a rape is there. But later I put sodomy. But sodomy also there in some places, and hence I removed it, sodomy, then I put the nuisance. So the C is not connected to the question. Fifth question. Next, sixth question. Section 100 of the IPC specifies situation in the exercise of the right to private defense of the body extend to causing death. The right of private defense of the body extends to the voluntary causing death or any other harm to assailant if the offense is of the nature herein described. Find out which one is false one in the four option. A. Assault having the intention of abducting or kidnapping. B option, an assault with the intention of wrongfully confining a person which may reasonably cause him to apprehend that he will not be able to take the protection from public authority for his release. C, an act or attempt to throw chlorine. D, an act or attempt to throw acid.
Option C, sir. An act of attempt to throw chlorine.
It is an act or attempt to throw. The chlorine is not there because chlorine is used for the water.
Yes.
Chlorination for the drinking purpose at the filter bed. Yes, anyone can unmute and read the seventh question. Student, participants.
Yeah, what are the question 7? What are the steps or stages in crime? Find out the correct or exact sequence. Option A, attempt, intention, preparation, commission. Option B, preparation, intention, attempt, commission. Option C, intention, preparation, attempt, commission. Option D, intention, preparation, commission, attempt. Option C, sir, intention, preparation, attempt, and commission.
It is the intention, preparation, attempt, and commission. That is the proper sequence of it. And with the feedback also, I give the same thing. Intention, preparation, attempt, commission. That is the proper sequence for committing an offense.
First of all, there should be intention,
Yes.
then preparation, then attention, and finally it is the commission of offense.
Yes, the act will be committed later. Mere intention is not an offense.
Yes.
Yes, eighth question.
Accepting food, sir. Accepting kidnapping, sedation, intention is punishable, sir.
Yeah. Eighth question. The motive under the 81 of the IPC should be dash. Option A, prevention of harm to person. Option B, prevention of harm to property. Option C, both A and B. Option D, either A or B.
Option C, sir, both A and B.
Option C is the right answer because it is the prevention of harm to the person and prevention harm to the property. Both the things will come over there. Next, ninth question. Infancy as an exception has been provided under dash. Under which section? By virtue of which section? A, section 80, B, section 81, C, section 82, D, section 84. Infancy.
No, sir, pass, sir.
The right answer is section 82. It deals about the infancy is an exception has been provided under the IPC section 82 is the right answer for that one. The next question, 10th question. Section 82 of the IPC provides that nothing is an offense which is done by a child under A, 6 years of age, B, 7 years of age, C option, 9 years of the age, D option, 10 years of the age.
Option A, sir, 6 years of age.
Wrong.
Option B is the correct one, 7 years of age.
Yes, option B is the correct answer. That is now switch out to the Kolikanda. Sharad Babu, continue with the 11th question.
11th question is section 82 of IPC enunciates A presumption of fact, B, a rebuttable presumption of law, C, a conclusive or irrebuttable presumption of law, D, none of the above.
Shoot.
Section 82.
Option C, sir.
Yes, option C is the correct answer. a conclusive or irrebuttable presumption of law, according to section 82. And 12th question is, a person is stated to be partially incapable under section 83 IPC if he is aged A, above 7 years under 12 years. B option is above 7 years and under 10 years. C, above 7 years and under 16 years. D, above 7 years and under 18 years.
Option D, sir. Above 7, below 18.
Option
Wrong.
A is the correct answer. Above 7 years and under 12 years.
Okay. Now, what does this question actually means? I did not get it.
That is
Apex.
the
Minor.
person who is above 6 years and under 12 years is incapable of committing a crime. Is it, sir?
Incapacitated means incapable.
Yes.
Okay. Yes, sir.
13th question. Under section 82 and section 83 of IPC, an offense is punishable if it is done by a child, A, of below 7 years of age, B, of above 7 years of age but below 12 years if is not attained sufficient maturity and understanding, C, above 7 years of age but below 12 years having attained sufficient maturity and understanding. D, all the above.
C, sir. Option.
Option C is the correct answer. A person of above 7 years of age but below 12 years having attained sufficient maturity and understanding is punishable if it is done by a child. So C is the correct answer.
Yes, sir.
14th question. Which of the following pair is not correctly matched? A, mens rea, R versus Springs. B, necessity, DPP versus bed. C, insanity, McNaughton's case. D, intoxication, Bosio versus state of Pepsi.
Option C, sir.
Yes, option C is the correct answer. Insanity, McNaughton's case. That is not
Yes, sir.
correctly matched.
Yes, sir.
The remaining three are correctly matched. 15th question. The maxim actus non facit rea nisi mens sit rea means A, crime has to be coupled with guilty mind. B, there can be no crime without a guilty mind. Option C, crime is the result of guilty mind. D, criminal mind leads to crime. Actus non facit rea nisi mens sit rea. This is a Latin maxim and its meaning is
Option B, sir. There can be no
yes.
crime
Option
without
B
a
is the
guilty
correct
mind.
answer. There can be no crime without a guilty mind. There should have a guilty mind to commit an offense. 16th question. In every statute, mens rea is to be implied unless the contrary is shown. This view was expressed in A, Sharos versus D. Rudgen. B, R versus Dudley and Stephen. C, Harding versus Prince. D, R versus Prince.
Option D, sir. R versus Prince.
No.
Option D.
Option A is the correct answer. Sharos versus D. Rudgen.
Okay, supplementary question. You know the R versus
Yes.
Dudley and Sifton, it's a famous case law. There is a wreck of a ship or a boat, only one plank is left, three persons are there, and the three persons cannot withhold the plank to reach to the destination. So each one of them killed, and they say it's a necessity, if I not be mistaken. And one person had reached to the bank. And
He says,
such a killing for the necessity is must, because they did not have any food to eat. So who is a smaller one, they killed him. Later on, the bigger one. Then only one is left over there, or two are left over there. That is the
two are
case.
left, sir.
If I am
Two
not
are
mistaken.
left. The child was killed for their life.
Hungriness. To quench the hungry. So that
Yeah,
is the R versus Dudley Stephen. Please correct it. Because they may ask.
it is also a famous case.
It's a famous case and it is not a necessity. With a necessity, you are not
Yes.
supposed to kill a person. It is an attempt to murder, that is. Next.
Yes. 17th question. The physical aspect of crime is actus reus. 2. The mental aspect of crime is mens rea. 3. The motive is the desire to commit crime. A. That is the first one. The physical aspect of crime is actus reus. Second one, the mental aspect of crime is mens rea. Third one, the motive is the desire to commit crime. A. 1 and 2 are correct, but 3 is not correct. B. Only 2 and 3 are correct. C. Only 1 and 3 are correct. D. All the above are correct.
1 and 2 are correct, sir. Option A.
Option A. All the above are correct. D.
The motive is the desire to commit crime. Okay.
Yeah. All the 3 are correct.
Because
All the
motive
above are
is ulterior intention is motive. Is it clear?
Yes, sir.
Yeah.
There
Got
should
it.
be mens rea, there should be motive, and there should be actus reus. All the 3 aspects should be. Now, 18th question. Section 84 of IPC provides for A. Medical insanity, B. Legal insanity, C. Moral insanity, D. Unsoundness of mind of any kind.
84. Option D, sir.
Option B is the correct answer. Legal insanity.
Legal
Section
insanity.
84 of IPC provides for legal insanity. 19th question.
Yeah.
Irresistible impulse is a defense A. in India, B. in England, C. in India and England both. Scroll down, sir. D. Neither in England nor in neither in India nor in England. Irresistible impulse is a defense in India, in England, in India and England both, neither in India nor in England.
No, sir. Pass, sir. Don't have any idea. Never heard about it actually.
Option D is the correct answer. Neither in India nor in England. Irresistible means uncontrollable desire. That is impulse.
Okay.
20th question. A hangman who hangs the prisoners pursuant to the order of the court is exempt from criminal liability by virtue of A. Section 77 of IPC, B. Section 78 of IPC, C. Section 79 of IPC, D. Section 76 of IPC.
Section 79, sir. Option C.
It is Section 78 of IPC.
78. Okay.
A hangman is not having criminal liability, is exempted from criminal liability according to Section 78 of IPC.
Is it 78 or 76?
It is 78, sir.
Are you sure?
Yeah.
Okay. Now let me take the 21st question. 21st question. Which of the following is correct? A. The burden of proof that the accused was not insane at the time of the commission of an offense is on the prosecution. And the B. The burden of proving that the accused was insane at the time of the commission of the offense is on the accused. C option. There is a rebuttable presumption of the fact that accused was insane at the time of the commission of the offense. B option. It is the matter of inference to be drawn by the court on the facts proved by the prosecution. Which one is the correct answer? Shoot, if that is wrong, it doesn't matter.
Option A, sir.
No. Second option?
Option B is the option
Option
B.
B is the correct answer. The burden of proving that the accused was insane at the time of the commission of offense is on the accused. The accused has to prove it. Is it clear?
Okay, sir.
Because our system is
Then
inquisitorial
A
system or
option is
adversarial system.
okay.
Our system is based on inquisitorial system or adversarial system.
Adversarial system, sir.
Civil law country will follow the inquisitorial system where the most of the role played by the judge. But in the adversarial system, it is the defense you have to prove it. If you want to prove it, yes, it is you have to prove it that he is a guilty person and he is having the guilty mind and mens rea. So adversarial system is there in the common law. So 22nd question. Insanity as a defense means that a person at the time of doing an act by reason of unsoundness of mind is incapable of knowing A, the nature of the act, B, that what he is doing is wrong, C, that what he is doing is contrary to law, D, either A or B or C. Which is the appropriate answer among the four? Are you with me? Shoot, even though
Yes,
it's
sir.
anonymous.
Yes.
D, sir, option.
No.
No, the nature of the act.
D. Either A or B or C. Of course, I wrote the small letter A. It should be a capital letter A. Is it clear? The nature of the act,
Yes.
that what he is doing is wrong, that what he is doing is contrary to law, because he doesn't know, because of the unsoundness of the mind at the time of the commission of an offense. 23rd question. For unsoundness of mind, the impairment of the cognitive faculty of mind to escape the criminal liability. A, must be total. B, must be partial. C, both A and B. D, none of the above.
Sir, question, sir.
The impairment, the unsoundness of mind, that is the impairment of the cognitive faculty of mind, cognitive understanding capacity of the mind to escape criminal liability.
Yeah.
It must
Must
be
be
total or it must be partial
must be
or both A and B or none of the above.
must be total, sir.
Yes, it must be total.
It must
Answer
be
A.
total. That is the answer for that one. Yes, 24th question. Intoxication as a defense is contained in the section 85 of the IPC, option A, option B, section 86 of the IPC, option C, section 87 of the IPC, option D, both A and B.
Section 85, sir.
No,
87 then.
both A and B.
A and B.
85 also deals and 86 also deals.
85.
Intoxication.
Okay, sir.
Next, 25th question. The doctrine, voluntary not fitting area, it is a law of tort doctrine, is contained in the section 87 of the IPC, option B, section 88 of the IPC, option C, section 89 of the IPC, option D, all of the above.
All of the above, sir.
It is all of the above is the right answer. Because voluntary not fitting area is there 87, 88 and 89 also. So the right answer is all of the above for the 25th question. 26th question. The maxim de minimis non curat lex means a law would not take action on small and trifling matters. B. The law does not ignore any act which cause the slightest harm. C. The law would not take action in serious matters. D. All of the above.
Sir, option A, sir.
Option
Small
A is the right answer. The law would not take an action on small and trifling matters. That is de minimis non curat lex. Next, 27th question. The principle, the de minimis non curat lex is contained in the section 92 of the IPC, B option section 93 of the IPC, C option Section 94 of the IPC, and the D option, Section 95 of the IPC. Which one is the right answer?
93, sir, of IPC. Option B.
No.
No, sir. Pass, sir. Not getting this.
It is a D.
D.
95 of the IPC, where that maxim is codified. The next question, 29th question. The right of a private defense is contained in which section? Section 94 of the IPC, B option, Section 95 of the IPC, C option, Section 96 of the IPC, D option, Section 98 of the IPC.
Sir, 98 section of IPC.
Wrong. The Section 96 of the IPC, the private defense is contained in it. The 30th question. The right to private defense is based on the natural instinct of number 1, self-preservation, option B, self-respect, option C, self-sufficiency, option D, self-reliance.
Option A, sir.
Yes.
Option A is the right answer. There is self-preservation is a defense based on the natural instinct of A is the right answer. Yes, Korikonda, you can continue from the 31st question.
Always a person tries to protect himself.
Yes.
So that is self-preservation.
Yes.
31st question is right to private defense is A, available under all circumstances, B, available where there is time to have the recourse to the protection of public authorities, C, available where there is no time to have recourse to the protection of public authorities, D, all of the above.
Option C, sir.
Option C is the correct answer. Available where there is no time to have recourse to the protection of public authorities.
Yes.
32nd question. The right to private defense is available with respect to A, harm to body, B, harm to movable property, C, harm to immovable property, D, all the above.
All of the above, sir. Option D.
Yes, that is the correct answer. D. 33rd question. Under section 98, right to private defense also is available against A, person of unsound mind, B, person who does not have maturity of understanding, C, both A and B, D, neither A or nor B.
Option C, sir. Both A and B.
Yes, answer C is the correct one. 34th question. Every person has a right of private defense of his own body and the body of any other person against any offense affecting the human body has been provided A, under section 96 of IPC, B, under section 97 of IPC, C, under section 98 of IPC, under section 99 of IPC.
Under section 98 of IPC. Option C.
No. The right option
Then should be
is B.
D, sir.
Option B
99.
is the right answer under section 97 of IPC.
Okay.
35th question. In case of A.K. Gopalan versus State of Madras, the Preventive Detention Act 1950 was found conflicting with two articles. A, Articles 14 and 17, B, Articles 19 and 21, C, Articles 23 and 25, D, Articles 23 and 32.
Option B, sir. Article 19 and 21.
Yes, option B is the correct answer. 36th question. One Mrs. Komal bought a car on the name of her daughter, Kiran, who is a minor, and got the insurance policy transferred on her name. That is Mrs. Komal. The car met with an accident on 2 counts and she filed for a claim on both the counts from the insurance agency. She acknowledged the receipt of money as Kiran. The insurance company has prosecuted her under the section 467 of the IPC alleging fraud on the appellant's part. Sir, scroll down.
Yeah.
A. Mrs. Komal is guilty of forgery because she made the insurance company believe that she is Kiran. B. Mrs. Komal is not guilty of forgery because the said deceit did not secure her any advantage as the entire transaction was that of Mrs. Komal. C. Mrs. Komal is guilty of forgery because she signed all the papers in the name of Kiran. D. Both A and C.
D, sir. Both A and C.
No.
Answer B is the correct answer. She is not guilty because she did not get any advantage as the entire transaction was that of Mrs. Komal.
Okay.
There is no deceit
Okay, sir.
because it's purchased on the minor's
No.
name.
On minor's name. Okay.
But she is the guardian.
Okay. Can I see the question once again, sir? I'll
Yeah,
take
yeah,
a
yeah,
screenshot,
yes.
sir.
Yeah.
Question.
Thank you, sir. Got it, sir.
Did you get it the point now?
Yeah, I've taken the screenshot, sir. I'll read
Very
it out,
good,
sir.
very good. Yes,
Now
37.
37, question number 37. Dishonest misappropriation of property knowing that it was in possession of a deceased person at his death and that it has not since been in the possession of any person legally entitled to it is dealt under Section 402 of IPC, Section 403 of IPC, Section 404 of IPC, Section 405 of IPC. A, B,
404
C, D.
C, sir. 404, sir. Of
Yes.
IPC.
Yes,
Right.
option C is the correct answer.
Misappropriation of a deceased person, sir.
Yes, yes.
If it is of living person, there should be 403.
Okay. 38th question. In which of the following death sentence is awarded? A. Waging war against the government of India. B. Abetting mutiny actually committed. C. Murder. D. All of them.
All of the above. Option D.
Yes, option D is the correct answer. In all these cases, a death sentence may be awarded.
Yes.
39th question. Sedition is an offense was held constitutionally valid in Kedarnath versus State of Bihar, AIR 1962, SC 955 under section dealt under A, section 124A of IPC, section 128 of IPC, section 136 of IPC, section 138 of IPC.
Section A, sir. 124A of
Yes,
IPC.
that is the Sedition Act.
Yes.
124A, capital A.
Yes, sir.
40th question. Who prepared the draft of the Indian Penal Code? A. Lord Canning. B. Lord Chelmsford. C. Lord Macaulay. D. None of the above.
None of the above, sir. Option D.
Option C is the
Wrong.
correct answer. Lord Macaulay. It is an important question. He drafted it.
Okay.
Lord Macaulay drafted Indian Penal Code. And
Okay.
he is also associated with the education system.
Okay, sir.
39th question. The Indian Penal Code is divided into what is that number, sir?
Yeah, it is the 10th, then the 11 plus 1 11 plus 20, 20, 23 chapters. Is it 23? X means 10.
First one, sir. First one I am asking.
Yeah, X means 10. 1x means 19. 1 means 3. I don't know how we should pronounce it.
Yeah.
Yes, X1 chapters.
Actually, there should be number. So
No,
we have
chapters.
Should
gone
be D,
somewhere
sir.
wrong. Okay, sir. A, B, 512 sections. B, 511 sections. C, chapters and 500 sections. D, 23 chapters and 511 sections. Actually,
Option
that
D,
is,
sir.
yes, sir,
Option
that
D.
is the correct answer.
Yeah,
23
and
chapters and 511
511
sections.
sections.
Indian Penal Code contains 23 chapters and 511 sections.
Yes, sir.
In framing the question, we have gone.
Yeah, a little. You marked some other thing here. Okay, doesn't matter. The idea is very much clear.
40th question. Yes. The Indian Penal Code 1860 came into effect or existence from A. 6th October 1860, B. 5th October 1880, C. 1st May 1961, D. 1st January 1862.
Sir, option D, sir. 1st January 1862.
Yes, option D is the correct answer. It came into existence from 1st January 1862.
Yeah, let me deal the
Almost 18
41st
months.
question. XYZ, the person having the sufficient food but does not provide some food to a beggar who dies of hunger. XYZ is a guilty of A. Murder. Option B. Attempt to murder. C. Causing death by a rash and negligent act. D. No offense committed.
No offense, sir. Option D.
But is a
Yes, option
moral
D.
offense.
No offense, sir. Yeah.
Okay, that is the answer because legally there is no liability will be there. And next question. X threatens to publish a defamatory libel concerning Y unless Y gives A. Defamation, B. Mischief, C. Option criminal intimidation, D. Extortion.
Once again, sir.
X threatens to publish a defamatory libel concerning the Y unless Y gives you money. He thus induces Y to give him money. And here X has committed the offense of what? Is it a defamation? B. It is a mischief.
sir.
C. Criminal intimidation. Or D. Extortion.
Extortion, sir.
It is an extortion of money because by threatening him, he want to get the money back. So that is extortion that we will say it. 43rd question. Criminal conspiracy is an agreement between the two or more persons to dash A. Option to do or cause to be done an illegal act. B. Option do or cause to be done an illegal act or an act which is not illegal by illegal means. C. Option commit an offense. D. Option none of the above.
Sir, option B, sir.
No. Conspiracy in Article 22, if I not, is it 22 or 20?
Sir, option B is the correct answer.
Option B is the correct answer. Do or cause to be done an illegal act or an act which is not illegal by illegal means.
Actually, Syed also said, Syed answered the same.
Yes.
Yes, sir.
So, 44th question. A and B agreed to commit the murder of C by poisoning, and D was to procure poison, but he did not procure it. A, B are guilty of dash. A, no offense. B, criminal conspiracy to murder C. B, abatement of murder by conspiracy. D, attempt to murder with the aid of section 34 of Indian Penal Code. Which is the correct answer?
Option D, sir. Criminal conspiracy to murder C.
Is it?
Option C, sir. Abatement of murder.
Abatement of murder by conspiracy. That is the right answer.
Yes, sir.
On the 44th question. Means C is the right answer if I not be mistaken. Yeah. 45th question. Indian Penal Code 1860 was enacted by British Parliament. Option A. Option B. Imperial Legislative Council. C. Option Hunter Commission. D. Option First Law Commission.
Sir, D, sir. First Law Commission.
No.
Option B. B is the correct answer. B. Imperial Legislative.
Imperial Legislative Council is the body and Indian Penal Code was enacted by that body. 46th question. Indian Penal Code was inherited by A. India, option B. India and Pakistan, C. India, Pakistan and Afghanistan, option D. India, Pakistan and Burma. Now it's called Myanmar.
Yes, sir. Option B, sir. India and Pakistan.
Option B is the right answer. That is India and Pakistan. Now, law of tort questions. The first question tort is a French word, B. English word, C. Latin word, D. Greek word.
It's a Latin word, sir.
But actually it is derived from the French word. It is when you say derived, you can say French. But actually taught, we can say the tortum. That is the Latin word. So here the right answer is, among the option you have to choose. That is the Latin word. Second
Latin
question.
word, sir.
Tort is a, number A, civil wrong, B, option criminal wrong, C, option civil as well as the criminal wrong, D, none of the above.
Option A, sir. Civil wrong.
But sometimes tort also a criminal wrong, but very few cases are there. Hence, the appropriate answer is
Civil wrong, sir. Option
civil
A.
wrong is the appropriate answer for this question. Then the third question. Okay, just I'm scrolling. Third question. Section 2, Clause M of the Limitation Act defines tort as A civil wrong which is not exclusively breach of contract or a breach of a trust. B, a civil wrong which includes breach of contract or a breach of trust. C, a civil wrong which includes a breach of contract but not a breach of trust. D, a civil wrong which includes breach of trust but not breach of contract. Which one is the appropriate answer?
Option B, sir. Includes contract, breach of contract and breach of trust. Option B.
Again, second option.
Okay.
As per the Limitation Act.
Yes, sir. D, sir. It should be D. Breach of contract. Not included breach of contract.
No.
Okay.
Answer
Breach of
is A.
contract.
A civil wrong which is not exclusively a breach of contract or a breach of trust. What the Limitation Act defines Section 2, Clause M. So fourth question. Who said tortious liability arises from the breach of a duty primarily fixed by the law? This duty is towards a person generally, and its breach is redressable by an action for unliquidated damages. A. Lord Atkin, B option Wimfield, C option John Salmon, D option Fraser. It is a definition given by the four authors. Who is the right person who gave this definition of tort?
John Salmon, sir. Option C.
No. It's a Wimfield. It's a Wimfield who has given the definition. Tortious liability arises from the breach of a duty primarily fixed by the law. This duty is towards the person generally, and its breach is redressable by an action for the unliquidated damages. Supplementary question. What is meant by unliquidated damages? What did you understand by the unliquidated damages?
Which cannot be compensated, sir.
No. Which cannot be ascertained in the beginning, in the first.
Okay.
It will be calculated or assessed later part. How much the medical expenses, how much the attendance expenses, how much the salary, how much the dependents, all this will be, slots will be made. Later it will be ascertained. That is called, unascertained damages are called unliquidated damages. But in the contract, it is always ascertained damages are there. Is it clear?
Yes, sir.
What is the classical case law which distinguish between the tort and contract? There are two classical case laws are there, which gives the difference between the tort and the contract. Supplementary question.
No, sir. I don't remember.
Bernard versus Huggies It's the tort defense, though it's the negligence. The negligence part is more over there. So it is independent of the contract and it is a tort. Rundle versus Jennings. That is a classical case law where it is say a contract with a minor is a void. That shows the contract. So Running versus Jandal is the classical case law which shows the contract. And the Bernard versus Haggis is a case law which shows the tort. Supplementary question. Okay?
Yes, sir.
Next, fifth question. Salmon has defined tort as A civil wrong for which a remedy is a common law action for unliquidated damages and which is not exclusively the breach of trust or other merely equitable obligation. B. Tortious liability arises from the breach of a duty primarily fixed by the law towards the person generally, and its breach is redressable by an action for the unliquidated damages. And C. An infringement of right in rem, I repeat, an infringement in right in rem of a private individual giving a right of compensation at the suit of the injured party. The D, none of the above.
Pass, sir.
If you see the B, we already read it. It's the Wimfield definition.
Option A.
Option A is the right answer. A civil wrong for which remedy is the common law action for unliquidated damages and which is not exclusively the breach of a trust or merely equitable obligations. It's the Salmon definition. Of course, mostly the Salmon and Wimfield definition will be asked. Very rare cases, Clark and Linsell, Fraser, James definition will be asked. The sixth question. The duty under the law of tort is A. Towards a specific individual, B. Towards a group of individual, C option towards the world at large, D option both A and B.
Option D, sir. Both A and B.
No.
Then it should be A then.
No. Because tort is against the whole world. Because contract
Crime
is
is okay.
in personam, in particular person, tort is right in rem, right against the entire world. No one should beat me. No one should touch me without my consent. It's not only to the only one person, to the entire world. Is it clear?
Then what about crime, sir?
Crime, even the crime also, no one can touch me without any excuse. But when you say that touch is assault and battery, assault is a tort, battery is a crime. Where the reasonable apprehension is made is a tort, which is called assault. Suppose somebody comes in front of you by a clenched fist to give a punch to you. At the time, you apprehend and go, your head may be black because the reflexive system works in the body. Is it clear?
Yes, sir.
At that time,
Still
it is an
offense is-
assault.
offense
But
is
once the
against
punch
the
will
state.
hit your face, it is a battery. That is called physical
Actually,
assault.
offense is against the state. It is considered as against the state.
Yes.
Means public at large. Is it clear?
Yes.
Yes, sir. Got it, sir.
It's Sarath Kumar. Sarath Babu, continue to the seventh one.
Yes. A tort is a violation of A right in personam, B, a right in rem, C, both right in personam and right in rem, D, neither a right in personam nor a right in rem.
Option A, sir. Right in personam.
See, this
just
contract
now-
right in personam.
Just now we have dealt with.
We dealt now a right against a person, particular person is a contract.
Yes, sir.
I said no one can touch me without my consent. It's right against the whole world. That is the right in rem.
Yes, sir.
Yes.
A
B is the
particular
right.
person means it is a contract between the two persons because the other person is identified. But here, who touched him or who punched him, who kicked him, who lashed him, unknown till the act is done.
So a contract is a right in personam, a tort is a right in rem.
Right in rem. Okay, got it, sir.
It's a basic
Eighth question.
question. Sometimes they can ask. Next.
Yes, sir.
8th question. Law of thought has developed mainly through A. Customs and precedents, B. Judicial decisions, C. Enactments, D. All the above.
All the above, sir. Option D.
Option B is the right answer. Judicial decisions.
Okay.
Of course, it may go off also sometimes the common law, customs also can be made over there, but exactly here the options are given over there. The right option is judicial decisions. Even customs also we can use it, and we'll use also some precedents because judicial decisions only becomes later on the precedents. Is it clear?
Yes.
Yes, sir.
Next, read.
A has opened a fish and chip shop in the nearby place to B's fish and chip shop. A has reduced prices of both fish and chips in order to close B's business. A has committed A. A tort, B. No tort, C. Offense, D. Both ends.
Yes, sir. Option A, sir. Taught.
No.
You have not studied the case law, grammar school case law. Gloucester Grammar School case law.
Yes,
Similar
sir. Means no intention was there. Yes, no taught, sir.
intention
B.
was, even though there is intention, it
But
cannot
damages were
be.
not there.
Yes. So
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We live in a world full